The Commonwealth just provided the court with information that causes me grave concern, Judge Beverly Canone said in court. The implications of that information may have profound effects on the defense and defense counsel. The new information involves communications with the federal government about experts from high profile forensic consulting engineering company ARCA. Based on statements made in court by prosecutors, the federal government told the defense that though a contract had ended with ARCA experts, the original materials were still protected. According to Brennan, this is what he said Tuesday. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. That and a whole lot more coming up. Alrighty. Hopefully you guys can hear me loud and clear. So Karen Reed is a 44-year-old financial analyst and an adjunct professor in Massachusetts. She's the defendant in a high-profile murder trial. Miss Reed was accused of striking her boyfriend, Boston police officer John O'Keefe, with her SUV and leaving him to die in impending snowstorm late January of 2022. Welcome in, everybody. So I think we're going to go ahead and jump right into this. Let's welcome in Charles, Beth, D-Mart, and Red Sauce. So this happened yesterday morning, and I'll let you guys be the judge.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible.
And there was
for
a
you.
lot on the schedule today. She just put an end to all of it.
And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is
up,
December
Cyber?
4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025.
Absolutely,
I think I
Beth.
said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract has ended. But
And we're going to talk a lot about the effects that experts have during a trial, which are huge.
that parties could contact ARCA. Obviously, the Commonwealth is in no position
For or against.
to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it
These guys start
one
panicking.
day to the 26th instead of the 25th?
That does not. It would have to be at 9 o'clock.
I mean, it's got to be awkward having to kind of get things scheduled right there on the spot. You got 1, 2, 3, 4 different schedules
The
that
discovery. That
Thank
was
you.
provided
Trying to
by
work
the
around.
reference by-
Oh, great, thank you.
Is there any way she needs to spend for today?
We can do the
Notice Karen
afternoon
on
of
the
the
mute button.
25th if the morning doesn't work.
she's no rookie.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
He didn't like that.
I'd rather be here.
Look how
but
ready he is.
I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live, I'd rather do it live, but I will accommodate the court's calendar.
That's a guilty face right there.
Are all parties available at 9 on the 26th?
I'm not.
May I have just a moment?
Thank you.
Karen's like, is this what I pay you for?
Your Honor, we'll accommodate the 25th, one way or the other.
Okay, so what does it all mean? Well, let's ask Michael Coyne.
Well, it was wow, right? I mean, when, the case that has taken on an incredible
It's a
number of
legal
turns,
analyst.
this happens to be the latest one. The court is very troubled by the ARCA experts and whether that information was properly disclosed, whether there was an attempt to mislead the court, specifically Judge Cannone, when she asked questions about had counsel spoken to these experts, and also the question about the payment of their fees and the like. So she is very concerned at this point and will dig a lot deeper, I imagine, at the next hearing with respect to whether misrepresentations were made to the court, to the jury, and to the prosecution with respect to these witnesses.
That's not good. This is very reminiscent of Judge Gohl and Baldwin and Rosie having a little tiff in the judge's chambers over in the Delphi murders. You guys remember that, where they were booted off the case? And this is huge. This was probably the biggest factor for the mistrial, right? Was all the confusion brought forth by these two experts, these ARCA experts, who stated in a court of law that the wounds on John O'Keefe are not consistent, and the damage, or not the wounds, but the damage on the vehicle is not consistent with hitting a pedestrian or hitting a person. A lot of experts have put innocent people behind bars and freed a lot of guilty men. So there needs to be some changes, I think, when it comes to these experts and the effects that they have on the jury. There's no such thing as a professional jury. So why do we have professional experts? The jury doesn't get to refine their skills, their analytical skills. They don't get to try again or do better the next time. They got to get it right then and there. So they're easy to persuade. They're rookies in it all. Always. I agree, Beth. Yeah, they're supposed to be paid. Don't get me wrong. They're supposed to be paid. But I think it's the clandestine fashion in which it was done. The ARCA were hired by feds, not defense team for first trial, for second trial. Well, they were presented by the feds and then hired by the defense. So here, let me read some information for you guys. And I don't think it's the fees. The fees aren't the problem. I don't think the fees are the smallest part of this. I think it's the fact that the information was said it would not be available during the second trial, but yet it was made available to the defense team. And because they're paying the bill, they had access to that knowledge and it wasn't provided in the discovery. Can't do that. Okay, understanding the power of forensic expertise in the Karen Reed trial. The forensic evidence holds immense power in shaping the outcomes of legal proceedings. And that's for every case. There's been cases where blood spatter experts come in and say, hey, I can tell you without 1 ounce of doubt, this person was standing 4 feet away from the victim and they pulled the trigger on a gun, fired a projectile, and that's how they got the overcast. When in fact, it could have happened millions of other ways. Could have brushed up against the victim's hair, causing, I don't know if you guys have ever taken a paintbrush and kind of pulled back on the bristles and kind of let go and seen what the paint does as it hits the paper or the canvas. Very same thing. DMart says, for the first trial hired by feds, info was available for prosecution also. Prosecution chose not to use then. That's not the point. It's about right now. What's available right now? And it was only made available to the defense. Yes, and I don't think the fees are the. I don't think anybody's worried about the fees. I think it's about the information that's being made available. It needs to be fair to both sides. Detailed coverage of the trial is available. In this case, forensic experts such as Dr. Marie Russell and the ARCA team provided critical insights that shaped the defense and prosecution's arguments. The article explores the backgrounds and roles of these expert witnesses, their specific contributions to the trial, and the broader implications of their forensic analysis. Everything depends on expert witnesses here. Did she hit John O'Keefe and cause these wounds with the back of a vehicle? These ARCA experts say, nope, we don't think so. Our expertise lead us to believe otherwise. Okay, so then what happened to him? That creates doubt. Beth says the defense told the judge they had no conversations with the witness before trial when in fact they did. Exactly. That's the point. The fees don't matter. Forget about the fees. Nobody's concerned about the fees. Not even sure why they brought up the fees. But Beth just hit it right on the head. The defense told the judge they had no conversations with the witness before trial when in fact they did. They advised the witness on what to say and not to say in court. You can't do that. There's going to be implications for this. Yeah, but they don't coach them, D-Mart. You can't do that. You can't coach your witness. If they're impartial, you don't need to coach them. You don't need to discuss questions and the expected responses. That's illegal. Fees matter because defense said they didn't hire them for the first trial, and but that's not what we're worried about right here. I'm not saying they don't matter in general, D. I'm saying that's not what we're talking about here. We're talking about discovery and the rules of discovery. And if you're claiming that these experts are impartial, that's not what the evidence as of right now that was presented today to the judge states. It's not impartial, and it was unfair. Nobody's even talking about the fees. The expert witnesses, Dr. Marie Russell and ARCA experts. Dr. Marie Russell, a renowned forensic pathologist, brought her extensive experience to the trial. She specializes in determining the cause of death through meticulous examination of injury patterns and biological evidence. Her testimony provided crucial details about the victim's injuries, significantly impacting the jury's understanding of the case. The ARCA experts, known for their proficiency in crash reconstruction, analyzed the accident scene, vehicle damage, and impact factors to reconstruct events leading up to the incident. Their detailed construction clarified the consequences of events, providing a solid foundation for the defense's arguments. The credibility of these expert witnesses significantly impacted the jury's perceptions, highlighting the importance of forensic evidence and legal context. So, just pulling some random person off the street, you're not going to know about crash reconstruction or what wounds should look like when flesh is impacted by whatever. So they're dependent on the experts. They're dependent and they're listening. And the word expert, right? You know what you're talking about. I really don't. I'm going to take into consideration the things that you say. And when you have all these experts telling you that there's no way that this man received certain injuries based off what the state is telling you, that could determine a guilty or not guilty verdict. Exactly, Beth. And that's the point of today's live stream. And that's what the trouble is. DMART says they can't be impartial. They have to be impartial. You can't be an expert if you're not impartial. When they determine one side's theory, they're not determining one side or the other. They're supposed to be determining what the facts, what the evidence is telling them, not whether they agree with one side or the other. They're just supposed to simply say, it's my expert opinion that this or this is what I believe happened. Not, I believe with the defense team I think you're missing it, D. It's not that they agreed. It's not about their opinion. Their opinion is what they're hired for, right? The question is it impartial? That's the question. No, experts cannot be impartial. You cannot be an expert if you go in there leaning already, wanting to support the defense team. Jumping the gun about what? Jumping the gun. All we're doing is reporting on what's been said. What's been said by the prosecution is that there's information being shared with the defense and the defense only by very important experts. You cannot do that. That's impartial. That's the argument right now. You can't be working with the defense behind the scenes and not providing that information to the prosecution. Yeah, it's not about what he said on the stand. That once again, that's the point I'm trying to make. It's not what he did on the stand, it's what he did behind the scenes. What they did behind the scenes. The communication between these experts and the defense team is what's in question. And the fact that the information was not provided to the court or the prosecution. Beth says the defense lied to the judge about both issues, conversations with the witness, and also stated witness received no monetary compensation. Okay, forensic pathology in focus. Dr. Marie Russell's forensic pathology expertise was central to the trial. Her analysis of injury patterns provided insights into the cause and manner of death, which were critical for both the defense and prosecution. Despite the continuous nature of her findings, Dr. Russell's ability to defend her analysis under cross-examination was pivotal, influencing the jury's perception. Forensic pathology involves numerous challenges, including maintaining objectivity and adhering to ethical standards, right? Including maintaining objectivity and adhering to ethical standards. And that's what we're talking about today, is maintaining objectivity. Dr. Russell's adherence to these principles bolstered the integrity of her findings and underscored the high-stakes forensic testimony in criminal proceedings. So they can't say the same thing about ARCA. Potentially, right? That's what the worry is right now. Her testimony was not without contention. The defense and the prosecution scrutinized her findings, leading to intense courtroom debates. These contentious aspects underscored the high stakes of forensic pathology in criminal proceedings. Dr. Russell's ability to defend her analysis under cross-examination was pivotal, impacting the trial's outcome and influencing the jury's perception. DMart says, I'm going to wait for the full hearing when defense responds. Judge should never have left this hanging yesterday. Absolutely, she should. Why proceed when you have possibly a poisoned situation? You don't continue to poison the proceedings. You stop them right then and there. You treat the ailment, which is this confusion about potentially non-objective witnesses that have already persuaded the jury once and will probably do the same thing in this trial potentially. You have to resolve those issues before you do anything, or else what's the point? You don't just say, oh, we might potentially have a problem here. Hopefully not. Let's continue. I don't want to waste everybody's time. You guys drove all the way over here. Let's just go ahead and do what we wanted to do, and we'll worry about this this issue another time. Nope, you have to stop. You have to put on the brakes, and you have to treat whatever is causing the issue. Okay, let's go over here and into the dynamics of crash reconstruction. The ARCA experts played a crucial role in reconstructing the accident scene in the Karen Reed trial using advanced methodologies and technologies. They analyzed the physical evidence to recreate the event timeline. This included examining skid marks, vehicle damage, and the positions of objects at the scene. Crash reconstruction involves technical intricacies that require specialized knowledge. The ARCA team's ability to present their findings clearly and convincingly was vital. The reconstruction provided a visual and scientific basis for understanding the accident, which was essential for the defense's strategy. Their findings not only supported the defense's arguments, but also challenged the prosecution's narrative. By presenting a coherent, scientifically backed reconstruction, the ARCA experts reinforced the defense's case, contributing to the comprehensive understanding of the incident. Welcome in, Free Radical. Brennan lied about who had sent him the emails. See, I've been seeing this on X. We just watched the video. He clarified exactly what happened. The defense sent them. Brennan stated the federal government. I can't believe the level of garbage the CW has perpetrated, and Brennan lied yesterday. So she even said that before they ended the hearing. She said, send me everything that was non-FBI directly to me, and then I'll get that from another source. So I don't know where that's coming from, Free. You're like the third person who mentioned that. I've been seeing that on Twitter, but that we just watched the video. So I'll judge it with my own eyes. It was still on record, D-Mart. Still on record. And also reiterated the issue. Has nothing to do whether or not they were hired, fired, paid, or not. It's the fact that they were not sharing the information and they're not being honest about it. I mean, imagine if the prosecution did something like that to Karen Reed. Everybody would be screaming for a mistrial. Her rights are being violated. But when it's the defense team, everybody's like, oh, we're going to wait. We're going to wait it out. No, this is potentially a very serious issue here. What do you mean? Has done it a lot with videos? All right. The Karen Reed trial underscores the critical role forensic experts play in shaping legal outcomes. Their meticulous work and clear presentation of complex evidence can sway a jury and steer the direction of a trial. Forensic science, with its multidisciplinary approach, bridges the gap between raw data and legal strategy, ensuring that justice is served through a thorough understanding of the facts. If you're looking for an expert witness for your next case, blah, 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 blah. So you guys get the point. You cannot backdoor an expert without tying in the court and the prosecution. I'm not saying that's what happened, but that's what may be going on right now. And if that is the case, that could have huge implication for Karen Reed's team. But D, you're right. We'll have to wait and see. I mean, we're not jumping the gun. We're not making any assumptions. What's up, Cindy? Now, here's an article that I had put aside here. Okay, bad science and bad statistics in the courtroom convict innocent people. Well, they should continue on here. Convict innocent people and let guilty people go free. Because it works both ways. It really does. Science, statistics, and expert testimony are crucial in securing justice, but their dubious applications in the courtroom can send innocent people to jail. The city of New York recently witnessed a record payout to George Bell, falsely convicted of murder in 1999. After it emerged, prosecutors had deliberately hidden evidence, casting doubt on his guilt, kind of like what the defense is doing here. They're trying to hide information so that it benefits them. Giving false statements in court. Bell is the latest in a long line of people, especially Black Americans, unfoundly convicted. More recently, Jabbar Walker and Wayne Gardine were cleared after decades in prisons. Conviction integrity units across North America have found serious flaws with many long-standing convictions. Alarmingly for scientists, misleading forensic and expert evidence is too often a deciding factor in such miscarriages of justice. Of the 233 exonerations in 22 alone, recorded by the National Registry of Exonerations, deceptive forensic evidence and expert testimony was a factor in 44 of them. I mean, just let that sink in for a little bit. The National Institute of Justice, part of the U.S. Department of Justice, has just published a report that found certain techniques, including footprint analysis, fire debris, and forensic signs, were disproportionately associated with wrongful convictions. Same goes for tool mark evidence. You know, before they didn't have the powerful microscopes that they do today. So now they're using the new technology to disprove connections to firearms and projectiles. The same report found expert testimony that reported forensic science results in an erroneous manner or mischaracterized statistical weight of probability was often the driving force in false convictions. The disconcerting reality is that illusions of scientific legitimacy, that's the key words right there, illusions of scientific legitimacy and flawed expert testimony are often the catalyst for deeply unsound convictions. Or right, getting people off the hook. Let's go to the Delphi case when they stated that something was plugged into the head, some headphones were plugged into the headphone jack from a certain time to another certain time. But in all actuality, you don't know if there was something just lodged into the port or the jack. And we heard an expert say, oh, well, it's my expert opinion that headphones were plugged in. And then the prosecution brought up their expert and they said, well, I did a Google search and apparently it's pretty common. If there's debris or even water in there, it could register that the phone has headphones plugged in. And everybody got all up in a tizzy about it, saying, oh, an expert? Well, it's not much of an expert opinion if it came from Google. Well, if it's common sense, it doesn't need to be an expert opinion. I mean, it's just common sense. Anybody with a cell phone knows that's happened to somebody that they know or to themselves personally. So it's dishonest on the part of the expert to say that, and it's not impartial. It's something very biased. It's biased behavior. The paradox arises because scientific evidence is highly valued by juries, which often lack the expertise to correctly interpret or question it. So it's like in layman's terms, right? Layman's terms is going right over the head. I mean, you guys just picked me up off the street. I'm a hairdresser. I'm a masseuse. I don't know anything about law. I don't know anything about crash reconstruction. I'll take your word for it. Unless the prosecution or the defense can sway me in another direction with their expert. But it's kind of like, which one can convince me the most? The jury, it's not like the jury really is comprehending what they're saying. They don't know how to rebuttal or refute or even do their own testing. How do we test it on our own? I'll just take your word for it. This is exacerbated by undue trust in expert witnesses, who many overstate evidence or underplay uncertainty. Absolutely. As a 2016 presidential advisor report warned, expert witnesses have often overstated the probative value of their evidence, going far beyond what the relevant science can justify. The debacle of British pediatrician Roy Meadow serves as a powerful exemplar of precisely this, famed for his influential Meadows Law, which asserted that 1 sudden infant death is a tragedy, 2 is suspicious, and 3 is murder, until proved otherwise. Meadow was a frequent expert witness in trials in the United Kingdom. His penchant for seeing sinister patterns, however, stemmed not from real insight, but from terrible statistical ineptitude. In the late 1990s, Sally Clark suffered from a double tragedy, losing 2 infant sons to sudden infant death syndrome. Despite scant evidence of anything beyond misfortune, Clark was tried for murder, with Meadows testifying to her guilt. Yeah, that's a tough one. That is a tough one. In court, Meadow testified that families like the Clarks had a 1 in 8,543 chance of a sudden infant death syndrome case. Thus, he asserted the probability of 2 cases in one family was this squared, roughly 1 in 73 million, of 2 deaths arising by chance alone. In a rhetorical flourish, he likened it to successfully backing an 80-1 outsider to win the Grand National Horse Race over 4 successive years. This seemingly impeachable, damning statistic figure convinced both jury and public of her guilt. Clark was demonized in the press and imprisoned for murder. And he didn't even have to go forward and prove his findings. You know, that's why when you have experts on the stands and they say, well, could this bullet, even though the tool marks match, can you say without a doubt that this bullet came from that gun? Well, no. But that's the same as saying, can you tell me without 1 iota of doubt that nobody else on the planet has the same exact fingerprint as you? No, there's no way to prove that unless you actually tested every living human being, you know, and took their fingerprint and compared them to each other. But it's the probability of it. That's what they use as the manipulative tool. The likelihood. And then trying to convince a jury of how you got to that likelihood. Oh, it's very scientific. You know what I mean? The jury's like, yeah, don't even try to explain it to me. Yeah, I'll take your word for it. Obviously, the prosecution or the defense can't argue it. If it's wrong, you know, their experts will come on and they'll hopefully show me why you're wrong. But that doesn't usually happen. Yes, this verdict horrified statisticians for several reasons. To arrive at his figure, Meadow simply multiplied probabilities together. This is perfectly correct for truly independent events like roulette wheels or coin flips, but fails horribly when this assumption is not met by the late 1990s, there was overwhelming epidemiological evidence that SIDS ran in families, rendering assumptions of independence untenable. More subtle but as damaging was a trick of perception. And that's what it is, a bunch of courtroom tricks. So especially, that's what bothers me about professional experts. Oh, what do you do for a living? Oh, I'm a professional expert for trials. I'm a trial expert. Oh, okay. While this implication was intended by the prosecution, such an inference was a statistical error. So ubiquitous in courtrooms, it has a fitting moniker, the prosecutor's fallacy. The variant of the base rate fallacy arises because while multiple cases of SIDS are rare, so too are multiple maternal infanticides, right? So it's almost like the same argument, but it would be more likely because you have the same DNA, the same situation, the same, you're putting these children exactly in the same place. They came from the same source, same DNA is shared, the surroundings that they're living in. So I think it's much more likely that something might happen to them or something similarly might happen to both children. So they have a great point. It's not, it's not some random act. To determine which situation is more likely, the relative likelihood of these two competing explanations must be compared. In Clark's case, this analysis would have shown that the probability of two Sid's deaths vastly exceeded the infant murder hypothesis. The Royal Statistical Society issued a damning indictment of Meadows' testimony, echoed by a paper in British Medical Journal, but such rebukes did not save Clark from years in jail. So it's kind of like right now we're hearing Baldwin with the Delphi case saying, well, I wish I would have done that, and I wish I would have done this. It's a little bit late when somebody's already either been convicted or freed. But I think you guys get the point on that. What's up, Rightfield? Good to see you. So what do you guys think will come of this? I'm not sure what the consequences could be. And I think there's a chance it could have been accidental. You know, maybe they just made a mistake. Maybe they didn't purposely hide this information or communicate with these experts behind the prosecution or the court's back. Maybe they didn't do it on purpose. What do you guys think? Okay, so Judge Beverly Canone's decision to adjourn the motions hearing and an unplanned recess that preceded it came after Special Prosecutor Hank Brennan argued in support of his new motion to exclude from the trial employees of ARCA LLC. The organization described itself as a multidisciplinary engineering consulting firm for litigation, insurance, military, sports, and more. According to Brennan, ARCA sent a bill to Reed's defense for $23,925. He said that the invoice was included along with correspondence between the defense, the federal government, and ARCA witnesses. Brennan read from several examples of the correspondence, including an example in which ARCA witness praised the defense. See, this is where it becomes questionable. Let me read this over. Brennan read from several examples of correspondence, including an example in which ARCA witness praised the defense for its questioning and an outline of questions and answers provided for direct examination. One ARCA employee specifically cited by Brennan was Daniel Wolf, an accident reconstruction expert with a background in electrical engineering and physics, who testified during Reed's first trial. At the time, he was described as a defense witness who was retained by the FBI, although Canone ruled that the jury did not need to be aware of that fact to evaluate his testimony. Wolf testified about pneumatic cannon, and he and his colleagues experimented with in this case. Must be part of their testing. Pneumatic cannon. He said their objective was to determine if the damage to Reed's SUV was consistent with the pedestrian being struck. He testified on the 29th day of trial that it was not. And that is huge for Karen Reed. That's like a three-pointer, and you got the foul. So it's huge. Might be the only reason that she got a mistrial. That's not trial by ambush, Brennan said Tuesday, calling back to an argument he made earlier in the day. That's getting duped. So I didn't know any of this. And that's what's up for debate right now. That's why they had to cancel everything, and that's what we're talking about right now. So in quotation, that's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides, creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts and create illusions and shields and say some things there and some things happening, federal investigation, and this person. And then this happens. I don't care if the ARCA witness testified at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And that's what we're talking about today. And the Commonwealth, like the defense, is entitled to discovery. Absolutely. If the roles were reversed, we can be talking about getting Karen off. So this is a big deal. Maybe. Brennan's argument came in the context of a hearing that included a defense motion to delay sharing impeachment evidence, which can be used to discredit a witness, until after witness complete direct examination. You know, it's putting the carriage before the horse. After he concluded his remarks, Canone called a recess. When she returned, Canone said, "The Commonwealth just provided the court with information that causes me grave concern. The implications of the information may have profound effects on the defense and the defense counsel." So, I mean, that's a threat right there. You know, she's telling him, hey, like, I have you in my scope right now. You guys don't fucked up, and we're going to talk about it. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. Yikes. That's all I got to say, guys, is yikes. But D was right. It could be nothing. Could be a nothing burger. Hopefully it's not. They don't need any more hiccups in this case. You know, they need this thing to run smoothly. I mean, how many trials are you going to have? Cindy says Karen goes free. Just my opinion. I don't know. This is a tough one. They don't have a whole lot of evidence against her, but I think all the evidence that they do have is against her, regardless what these experts say. Sometimes common sense is always the biggest elephant in the room, right? And I think some juries might ignore the elephant, but I think most are okay with it. And they're pointing at it like, hey, you guys see that, right? Kind of like what they did in the Delphi case. But we'll spend the last 10 minutes chopping it up. What's up, CJK? Inquisitive. Welcome in. So I'm going to go get comfy. Hopefully you guys can hear me okay. So what do you guys think? We can talk about your opinions about the case, about what you think might happen with the defense team. Maybe it's a nothing burger. Me personally, I feel like the evidence is telling us that she's guilty. I mean, why would these cops, first of all, leave a dead body or somebody out there to die right on their own yard when they can just go dump the body? Why would they dump the body and then create this huge high profile case by setting up one of their own friends? Like, the evidence, even though that it could happen, the evidence doesn't point to that. And unless you have something really powerful, nobody's going to buy into that. But when you know the facts of the case, for instance, Karen and John were not really getting along too well. We know that because of the text messages. Thanks, Rightfield. the broken tail light on the ground, the fact that they were out drinking, the arguments on the text, through the text messages, all of that. I mean, it points to her hitting him, whether she did it on purpose, out of anger or not. It points to that's what happened. Could that be wrong? Yes. But unfortunately, there's no information that points to that. The only thing that was supporting that were these experts. So I think the bigger question is, what is a trial expert? Is that what you do? I mean, that's what you do for a living. You just continually go to different trials. You're not going to be hired by the defense and then say, oh, sorry, defense, but I got to go with the prosecution on this one. I know you guys are paying my bills. I know you hired me, but I disagree with you. Because the truth is, they're not going to call them up on the stand. There's been a lot of issues with ex parte information being leaked to opposing sides, and then the opposing side using that expert that has been asked to step away because of their findings. Well, your findings are not helpful in my case. We're not going to call you as a witness. Now, it's important to hide that information from the prosecution or the defense. That way they can't come in and say, hey, well, you guys hired this guy as an expert. All right, jury, I want you guys to understand this. The defense hired this expert. Then they got rid of the expert because this expert agreed with the prosecution. Well, now we're hiring this expert and he's going to testify for us. It's not ethical, but it does happen. It almost happened in the Delphi case. What's up, Lynn? Let's go to Beth. Seems to me the judge directly asking the defense if they've had conversations with that witness and the defense lied to her. There was a reason for that. I think Reed is guilty. I don't know if that means Reed is guilty, but I agree with what you're saying up until that point, because that I don't know. The evidence is pointing to her guilt. Absolutely, in my opinion. But you're right. The judge directly asking the defense if they had conversations with that witness, and they told him no. And then his face just getting so red, the judge being so pissed off, like, you fucking lied to me. You lied to me. It's my duty to, oversee everything that's happening in this trial, and you slid one right past me. And the fact that you slid one past me and it having to do with some of the most important witnesses in this case is not just something to gawk at. Like, we're going to cancel everything today. We're going to figure out what the hell happened. And this could have implications for the defense team. What's going on, Cheeks? Beth says, yes, his face was so red and he did not say a word. He panicked. Like, I'm busy. I can't, I'm not free that day. And then everybody was just all panicked, almost like they talked about this. You can almost see the guilt. Like, hey, if we're going to do this or if we're going to do that, we got to keep it hush hush. And the thing is, it's not easy defending a guilty person. What's up, Mustang? So if you guys have anything to add to this, let's get it into the chat now. This is about our 5-minute warning. But we are going live later. We're going to spend a lot of time on the air. We're going to talk about the Delphi case. I'm going to open up the phone lines. And we'll see if we can get anybody to call in with some opposing views. Cheek says, I've missed it. I've been at work all day. What's the happening? Well, it appears that the defense may have been communicating behind closed doors with some experts who have sided with the defense team. And they were kind of having a one-sided conversation about certain questions that were asked and how they were answered, and kind of like a coaching ordeal. And this all happened behind the back of the court and the prosecutor, specifically after the judge asked the defense if they've been in communication with ARCA. They said no. Well, in fact, they have been. Lynn says he would lose his license if he did lie. Wow. See, I don't know the consequences. I don't know the implications. Oh, tonight we're going to be talking about the Delphi case. I might be rescheduling the members only meeting at 4. We might be doing that tomorrow at noontime, Arizona time. But tonight we are going to spend probably about 2 hours talking about the Delphi case. Lynn says more questions. CJK, okay. That's what you call up close and personal. I'm watching you. Hey, Fokker. I'm watching you, Fokker. There's that better? All right, guys. If you are part of the replay crew and you think this is a nothing burger, or you're expecting some disciplinary actions by the judge towards Karen Reed's team, let me know. This happened yesterday. They had a whole lot on the docket that day, and everything was just shut down. The judge got really pissed off. You could tell that she was upset. She was flustered. And Karen Reed's defense team became all confused and became really flushed, I guess, red-faced. Me personally, I think this is huge. I think something big is going to happen here. I think there will be some repercussions, but that's just me. All righty, guys. I think that's going to do it. Beth says, I think it's huge. I think it will be. This is not good for Karen. It's not good for the whole situation. Lynn says the emails are not good. I agree with you guys. Okay, if you guys are part of that replay crew, you know what to do. Leave a comment and we'll get back to you as soon as possible. Feel free to share all of your thoughts about the case down below. And that's going to do it. We've been really busy today, so I got some things I got to take care of, some personal things. But we will be live again later today. So all you members, big shout out to you. All you people who continue to donate to the channel, thank you. Subscribers, moderators, trolls, whatever. If you're tuning in, big shout out to you. And I'm going to see you guys again very soon. Probably, I would say 3 hours from now. So you take care of yourselves. Thank you for tuning in to the Sleuth Intuition channel. I hope you enjoyed the broadcast. If you're in the Phoenix metropolitan area and you're interested in being a guest here on the Sleuth Intuition channel, please give me a call here at this number or shoot me an email there. I look forward to hearing back from you. Have a great day.